Good morning, and thank you, Your Honor. My name is Celine Humphries. I represent the plaintiff, John Campbell, in this suit for the wrongful death of his wife, Judy Campbell. I would like to reserve 5 minutes for rebuttal. I'm hearing feedback. Am I too close? I normally don't have that issue. Maybe if I step back a little bit?
I think that's better.
I'm pretty loud, so I think we'll be fine. I can do that. I did want to reserve 5 minutes for rebuttal, if I may. I want to get right to the point. I am the appellant here challenging an evidentiary ruling. I have an uphill battle before the court today. I first have to establish an abuse of discretion by a trial court in ruling. I second have to contend with your analysis of harmless error. Is there a reasonable possibility or probability that the verdict that resulted was affected by the evidentiary ruling? So recognizing that and hearing your comments about being brief, Judge Wallace, I'm going to focus right now on issue 1 unless you want to ask me anything about issue 2. Issue 1 is the point that the trial court prevented plaintiff from presenting addiction opinion testimony from the only 2 witnesses who had actual contact with Judy Campbell. Now, there were 3 arguments made for this by the defendants below. First, they repeatedly argued that the plaintiffs had not disclosed, I'm starting with the pulmonologist, excuse me. There were 3 arguments that the defendants made for excluding one of those witnesses, Judy Campbell's treating pulmonologist. The defendants argued that that doctor was never disclosed for giving that expert opinion. We showed the trial court the interrogatory answers that clearly said that, and we told the trial court that the deposition testimony, the defendants well vetted the issue. Defendants have dropped that issue now. So getting to the point of what they do argue. What they argue, they focus on cumulative. And Judge Wallace, we cite opinions in which you have ruled on this very issue twice in 2013. One, you were on the panel in Oleski, and the other, cited by Oleski as well, is the Perez case, a criminal case. And in that, you discuss, Perez you wrote, in that you discuss what the test is for cumulative evidence, and it's not whether the same content is given by multiple witnesses. It's not the same ultimate statement.
But isn't, I mean, the main problem with, I think the doctor's name was Martinez Salas,
yes,
and he says that in his deposition he testified, I'm not a specialist in addiction, I've never done any research, I don't have any data, I'm not at all an expert on this, and if I testified or gave a medical opinion on the fact of addiction, I would only be speculating. I mean, he said all those things.
I think that last point is where I would take issue. This is an argument that comes up a lot in the Engel progeny trials. Is somebody an expert in a particular field? And what you will find these doctors say, because they're scientific specific individuals, the doctors will say, I am not an expert in psychiatry and psychology. I am not a person who treats addicted people for that sort of disease. So I am not somebody who has that psychological training and background. And yes, when defense vetted that with him, he was an open and honest man and expert. But if you read the rest of his deposition, he explains, remember the other basis for being an expert, and that is based on experience. So this pulmonologist, the majority of the people he treats are people afflicted with an addiction to nicotine.
And of course, again, by the time this doctor saw this lady, she'd already stopped smoking.
That was one of the arguments made, not at the trial court level, but on appeal. It was made briefly at the trial court level. The trial court did not adopt that reasoning. I will say that there was a line in the transcript. That is made on appeal. First of all, wasn't the basis of the trial court's ruling, so it can't be a tipsy coachman on a discretionary point. But more importantly, that misses the point. That's the weight of the evidence, if anything. Look at the fact that any expert, what are they basing their expert opinion on when they're dealing with a human being? It's interviewing the person. The fact that he didn't see her smoking, that's one of the points they argue in the answer brief. He doesn't have firsthand knowledge of watching her smoke all the time. And secondly, she had quit smoking. That doesn't undermine the fact that he did talk to his patient and gather that information. Now, if they wanted to make the points you're making, yeah, but she had quit 10 years ago.
Well, I'm not making a point, I'm just asking a question.
Oh, I didn't mean to be too
Well, on that line, though, I understood that in addition to the things that he talked about, he said he had not even talked with her about her smoking history. Have I misunderstood that?
I believe that you did. He did, in fact, talk with her. He did know about her history of smoking and her frequency of smoking. He did not go into the level of detail that an addiction expert would do and a full history of somebody smoking, but he did work with his patient and he did understand her history of smoking. And in fact, remember, this is a key point. He's the man who wrote and signed the death certificate. In the death certificate, he wrote the cause of death was an addiction to nicotine. So that goes, again, to your question that defendants have raised, not that it's your point that you're arguing, that he believed, as an expert, as a pulmonologist, in his practice and experience of dealing with his patient, regardless of whether or not she's smoking today in the waiting room or outside the office building before she comes in, or whether she was smoking 10 years ago, he did believe that he could diagnose her.
Well, let me ask you this, Ms. Humphries. I mean, in the context of these kind of cases where we're, I mean, we can use the term addiction for a lot of reasons and in a lot of different contexts, but wouldn't you agree that in this context it's being used as a very specific clinical term?
Actually, addiction is not defined for the jury. The jury is not, unlike negligence, the jury is not told what addiction is. What the jury is given is competing definitions by both parties. The parties will even disagree as to what the actual basis for addiction is. So that's part of what they're deciding. And to the extent that you're saying, is it in a precise legal term, I'm going to...
No, it's a clinical term.
I'm sorry, and that is what you said, and that is the correct thing. Is it a clinical term? That's an argument also raised regarding the second of addiction opinion that was excluded, and that was Judy's son, Greg Strickland. And in that context, we direct the court to a very similar line of cases regarding the Florida Supreme Court allowing a lay person to give testimony regarding whether or not someone is insane. Equally, a very specific clinical term.
Well, you know, as far as the son was concerned, I mean, he testified that she was a chain smoker or almost a chain smoker, and then at one point I think he said she was hooked on cigarette smoking. So I wonder, you know, how much difference would it make if he'd been allowed to say the magic word, she was addicted, instead of she was hooked?
That's one of the things I love about this case. Normally, I'm afraid here on an evidentiary ruling, not because of the error question, but because of the harmless error analysis. Here, you have the jury having asked for an opinion, a true opinion from someone based on firsthand knowledge. Regarding the son, to the extent that he may have said hooked at one point, that does not mean that he gave the addiction opinion testimony. That means that he attempted to describe the pattern, and defendant's view of the pattern, based on someone trying to describe what he saw, was she repeatedly chose and chose and chose to smoke. The best way that Greg could describe what he saw his mother doing was to give that opinion of she was addicted. I could tell from everything about her, she was driven by...
But from a layperson's point of view, what really now is the difference between saying she was hooked and saying she was addicted?
You just made my point about harm. That is the issue in these cases. The very same conduct of the plaintiff. The number one issue in every one of these trials, and there's been many of them now, in every trial is the defendants argue that the only reason, they don't argue a comparative fault, the only reason a person smoked and exhibited that pattern is because they chose to. That very same pattern that you're looking at going, well, isn't it obvious? Defendants forcefully and persuasively and powerfully argue that that pattern of just how she's behaving is simply a choice, that she enjoyed it, just like she drinks a lot of coffee, just like she eats potato chips or whatever else. It is essential for us to be able to offer the testimony to the jury to help them understand what that conduct really was. And we don't say it was all addiction, but we say that it was in part motivated by addiction, meaning that her choice was constrained. It wasn't 100% her choice. She was being driven by her addiction to nicotine. So that's the difference in the evidence between what he was allowed to say and what he wasn't. I want to make another point about harm, if you don't mind. Remember that the treating pulmonologist took the stand and he was allowed to testify to some extent. When the addiction expert took the stand, he premised his testimony exclusively on those
So
people.
she, wasn't it?
Pardon?
It was a she.
I'm sorry, yes, thank you very much.
Dr. Brady?
Dr. Brady, yes, very trained, thank you very much. Unfortunately, I participate in a lot of these trials, and usually there's a male addiction expert, so thank you. And she did testify based on cold, hard record. And a large part of that were the medical records prepared by the pulmonologist who testified at the beginning of the trial. So the jury, 2 jurors asked him, how can you be giving this testimony when you never even talked to her? So 2 things arise from that. First, he said, I admit, the gold standard is talking directly to the patient, and that's usually what I base my opinion on. So he conceded that that is true. Secondly, the jury knew that the guy who wrote the medical records was there and didn't speak up. So that's evidence, again, of the harm. The jury was looking for testimony from people who witnessed her firsthand. Add to the point bias. She, the medical expert, was a retained expert, paid a fee.
Well, it seemed like she was one of the best, if not the most qualified addiction experts in the country. And in fact, I think one of the defendants, I can't remember which one it was, had actually employed her in another trial and conceded her expertise. And she was very, very clear that, in her opinion, this lady was addicted to nicotine.
But that's not the point for cumulative evidence, right? As you discussed in Perez, it's not the fact that the content would have been the same or that she was just a really, really, really great expert. It's the quantitative difference. It's the qualitative difference between the perspective of a pulmonologist who does this day in, day out, hands-on treating patients who are ill, versus an expert who comes at it from the addiction perspective. They have very different backgrounds. So together, from their perspectives, these 2 qualified individuals were reaching the same conclusion. And the jury needed to hear that. So to the extent we're focusing on the cumulative, and let's step back for the standard, should Dr. Martinez-Salas's testimony have been excluded because it was cumulative, it does not meet the test for that. It was a different qualitative standard of evidence or type of evidence to be offered. Add to that the fact that both the lay opinion and Dr. Martinez-Salas were based on actual interaction with Judy Campbell. So if they want to challenge, well, she had stopped smoking a while ago, okay, you could tell the jury that. How well did she remember when she told her treater that? If they want to challenge that he didn't see her smoking firsthand or whatever, that's kind of even silly. I doubt they would make that argument to a jury, because how's a pulmonologist going to see their patient outside? That's not a traditional thing. The pulmonologist, like any doctor in any tort case, bases their opinion, when it has to do with the conduct of the patient, on what the patient tells them. And if there's any deficiencies in that here, it's not a basis for excluding the evidence. It goes to weight. And it certainly does not establish that that the evidence is cumulative. So just as in Perez, and just as in Oleski, it was error for the trial court to conclude that the opinion testimony from the pulmonologist who wrote the death certificate and wrote on it that an addiction to nicotine caused her illness and death should have been allowed to talk to this jury. Going to the demonstration of harm, I understand in the In Re AB case in March, and you were on the panel for that, this court has held that the new special test does not apply retroactively. I decided not to vet that with you. I supplied you special as a supplemental notice just last week. I supplied you a 4th DCA case that on rehearing applied special and ruled for the appellant on a discretionary standard, finding that the appellee had the burden. I don't think it matters here. I don't think it matters here who has the burden. Even under the old standard, we would prevail on the harmless error standard. One of the things I pointed to was the jury's 2 questions, the 2 jurors' questions. The other thing was the incredibly fast verdict. Another point, because of how these cases are tried, Your Honor, we actually have the itemized question showing what the jury decided on. The jury decided against the plaintiff on this question, addiction causation. And then the last point demonstrating the harm resulting is the fact that Addiction causation is the pivotal core battle in all of these trials. There may be a question sometimes about residency for class membership, as in the Damianakis case. There may be a question about statute of repose, as in the Hallgren case. But every one of these cases, the battle is this, addiction causation. And plaintiff was denied the opportunity to present fundamentally important evidence to meet the plaintiff's burden. If you have no further questions, I'm going to reserve the rest for rebuttal.
All right, you've got 5 minutes left then.
Thank you, Your Honor.
May it please the Court, Amir Tehrani for appellees. The evidentiary rulings that the plaintiff is challenging on appeal are not a basis for overturning the judgment below. Those rulings rest well within the trial court's broad discretion, and in any event...
Can I ask a question? I don't mean to interrupt. But I asked your opponent this question, and I'm confused now, because the trial court appeared to exclude the testimony of her treating pulmonologist. And among the things the trial court said was that pulmonologist never even discussed with her smoking history. So was the trial court wrong?
The trial court is correct, Your Honor, and I would point the court to page 15 of our answer brief, where we quote the relevant portions of Dr. Martinez-Salas' deposition. And those are reproduced in Appendix D at page 117. And the relevant question and answer was, and there was no description in your records that she described to you that she had any difficulty remaining absent from smoking during your course of care and treatment of her, correct? Dr. Martinez-Salas responded, no, that was not part of her care. We never had to visit about smoking cessation during my visits with her. Then a few pages later, at page 117, Dr. Martinez-Salas states, during the time that I treated Ms. Campbell from 96 to 2007, we did not discuss smoking cessation. So Dr. Martinez-Salas' deposition in this case makes very clear that Mrs. Campbell and the doctor never had the opportunity to discuss smoking cessation or her smoking history. She had quit smoking by the time that Dr. Martinez-Salas started treating her for COPD in 1996. In addition, Dr. Martinez-Salas further acknowledged during his deposition that he's a pulmonologist, that he lacks any background in addiction, and that he's not an addiction specialist. He went so far as to admit that any opinion he offered on the topic of addiction in this case would be, quote, speculation. So given that candid acknowledgement by Dr. Martinez-Salas and the fact that he further admitted that the topic of addiction and smoking cessation never came up during his course of treating Mrs. Campbell, the trial court acted well within its broad discretion in preventing Dr. Martinez-Salas from offering a speculative opinion on the topic of addiction. In addition, any testimony that he did offer on that topic would have been wholly cumulative of the testimony of Dr. Kathleen Brady.
Well, even so, if it's merely cumulative, I think we have a bigger problem than we have if he doesn't have the foundation or the expertise or any of the information. Because I think, our Oleski case and other cases, tell us the failure to allow expert testimony, even when cumulative, can be reversible error. So, I don't know how you can make the argument that it's cumulative when you've just told us that he didn't have anything to say in this area. So, help me with that.
Well, the point, Your Honor, is that if Dr. Martinez-Salas had offered an opinion with respect to addiction in this case, he would have done so based on his examination of the medical records before the time that he began treating Mrs. Campbell. And that is the same basis on which Dr. Brady formed her opinion with respect to Mrs. Campbell's alleged addiction. So unlike a treating physician in the typical case who is able to draw upon his conversations with the patient, his firsthand knowledge of that patient's medical condition, Dr. Martinez-Salas in this case would have been looking at the same cold medical records that Dr. Brady, the retained expert, examined in forming her opinion with respect to addiction. So we believe that the cumulative nature of the testimony was an additional ground for excluding it here. But even setting that aside, the fact that Dr. Martinez-Salas acknowledged his absence of relevant expertise, the speculative nature of his testimony, and his not having discussed or treated Mrs. Campbell for addiction were sufficient grounds standing alone to sustain the trial court's ruling in this regard. With respect to lay opinion testimony from Mrs. Campbell's son, Mr. Strickland, neither of the requirements for lay opinion testimony under 90.701 is met in this case. First, addiction is not a concept that it's impossible to convey without using terms of opinion. It's a concept that a witness can convey based on his perceptions or observations of a smoker's behavior and smoking patterns. And that's exactly what Mr. Strickland was permitted to do in this case. He testified that his mother, quote, smoked constantly, that she was, quote, hooked, and that she smoked throughout the day. Those data points, those facts, are precisely the type of information that a jury should be presented in making a determination with respect to addiction. But there was no need for Mr. Strickland to go the extra step of opining on addiction, given his absence of any relevant medical training or experience. In addition, any error with respect to either of these addiction rulings was harmless. As an initial matter, we don't even know whether the jury's determination that Mrs. Campbell was not a member of the Engel class rested on the conclusion that she was not addicted, or on the conclusion that any addiction was not a legal cause of her COPD and death. There are two elements to Engel class membership. The first is addiction. The second is legal causation. In this case, those issues were presented to the jury in a single verdict form question. So it's possible that the jury concluded that Mrs. Campbell was addicted, but that her addiction was not a legal cause of her COPD and death. Therefore, the exclusion of a testimony that went exclusively to the issue of addiction can't be prejudicial error in this case, where it's unclear whether the jury rested its decision on addiction or on the legal causation element of Engel class membership. The plaintiff had the opportunity in this case to request a verdict form question that broke down class membership into its two discrete elements, addiction and legal causation. He failed to do so, and his failure means that he can't be heard to complain here of evidentiary rulings that go to the question of addiction. In many respects, this case is analogous to the First District Court of Appeals decision in Webster versus Body Dynamics. In that case, the plaintiff in a products liability action challenged the exclusion of evidence regarding a nutritional supplement that the plaintiff was challenging as defective. The First District on appeal concluded that any error with respect to this evidence that went to defectiveness was harmless, because the jury may well have concluded that the product was defective, but that it was not the legal cause of the plaintiff's injury. Likewise, in this case, the jury may have concluded that Mrs. Campbell was addicted, but that her addiction was not a legal cause of her injury. Second, there's no reasonable possibility that permitting opinion testimony from Dr. Martinez-Salas and from Mr. Strickland would have changed the outcome here, given the extensive evidence that the plaintiff was permitted to introduce with respect to the topic of addiction. Dr. Martinez-Salas, while not permitted to offer an opinion on addiction, did testify that he reviewed the prior medical records before the time he started treating Mrs. Campbell, and that those records included a document in which a physician labeled her a tobacco abuser. And Dr. Martinez-Salas opined to the jury that, in his view, tobacco abuse is the same thing as nicotine dependence. So he effectively offered an opinion with respect to addiction in the form of his statement with respect to nicotine dependence. And the same thing with respect to Mr. Strickland, who testified that his mother was, quote, hooked, and that she smoked constantly and was a chain smoker. In sum and substance, that testimony is equivalent to an opinion with respect to addiction, permitting these two witnesses to mouth the word addiction would not have changed the outcome of this trial. With regard to the remainder of the issues, we'll rest on our papers if the court has no further questions.
All right, thank you, Mr. Tirani.
Thank you.
I'm going to follow up on your specific questions regarding what Dr. Martinez-Sasalas believed he could testify to. On page 7 of our reply brief, we quote from that deposition. It's volume 45 in the record, page 8959. Do I think she was addicted to nicotine? Of course. He clearly states, if you read through his deposition, that he does have an ability and expertise in addiction by virtue of his experience as a pulmonologist. The portion read by defendants, listen carefully. It says, during the course of treatment, this is from their brief, but they wrote in their brief, on the answer brief, during the course of treatment, he did not have to help with smoking cessation. That's not the same thing as not discussing a smoking history and having a basis for the opinion he gives. Was she addicted? Did he, unlike other patients who come in currently smoking, did he have to work with her to help her quit smoking? No, and he answered truthfully. I didn't have to help her with smoking cessation. That's what that testimony is about. He is not testifying that he does not have an evidentiary basis or the experience as a pulmonologist to give an opinion of whether or not she's addicted. Similarly, addiction specialist. Read that. If that's troubling you, I ask that you read that carefully, and I apologize for not vetting it better in the reply brief. He does not think that he's anything close to the Harvard-trained expert on addiction. He does not think he has a background and a degree and a PhD in psychology and have that kind of perspective and focus on the science of addiction. And he was honest about that. He's a scientist. He's not going to say he...
Opposing counsel made the point that Dr. Martinez-Salas was permitted to testify that this lady was nicotine dependent or suffered from nicotine dependence. So does that take care of the addiction controversy?
It does not, Your Honor. And if it did, why would we have those two questions from the jurors? Why do we have the two questions from the jurors saying, how can we have an addiction opinion testimony, an opinion about addiction, without anybody testifying as to seeing her or talking to her? If that is true, the jury didn't hear it, and I don't believe it is true. He was not able to make that next step and say, I deal with patients all the time. Here's my experience. Here's my expertise. He was not allowed to explain any of that to them. He was not allowed to explain why, as a pulmonologist, as a medical doctor, a treating physician, as opposed to a psychologist or psychiatrist, why he reached the very same conclusion. And again, he's not paid. He's somebody that the plaintiff went to long before she had a lawsuit. She went to him to be treated for a fatal disease. He has an unbiased opinion from a very different background. The fact that they reach the same conclusion and have a duplicative content, to quote from Perez, is not duplicative qualitative evidence. It's not the same evidentiary value. And then the point I started making was those comments, those limited comments about him not being a specialist, does not mean that he did not think he had the ability to testify at trial. And more importantly, that was not the trial court's basis for excluding this evidence. So I asked the court, applying whatever standard of harmless the court applies, to find, first of all, that an error did occur, and secondly, that there is a reasonable probability that impacted the jury on the first question. Was Judy Campbell addicted, and did addiction cause her disease? Thank you.
All right, thank you both. This case was well argued.